crush on Brad Pitt.
Well, any reasonable person should, if I had to.
I'm just saying it's not true at all. But as it happens, like those are two phenomenal movies. I mean, you gotta be an idiot not to think so. So
I don't know. I think you have a man crush. I definitely go down that. So we are live.
Obviously. No stream can begin or end without me being in the middle of a sentence. That's just the way it is.
Of course, Anton. We've got to take care of Anton LaVey, the wisdom of the church. Have somebody new with us. Lee, can you introduce yourself?
Hi, I'm Alita, also known as LegalBytes. I've had this channel for just over a year, actually. Just a week ago was when we crossed the year-long threshold. So I'm super excited to be here. I'm super stoked. I watch all your guys' channels. I've been streaming with Nate the lawyer for a little bit, and also Uncivil Law. He was streaming with us for a while. I know Nate's going to be joining us later. But I'm super excited to meet you guys, and yeah, hang out, talk about law stuff. I
saw your work. I'm sorry.
Go ahead, Joe.
No, I saw your work one time with Nate and Uncivil, and what you guys were doing is you were breaking down, as I recall, oral arguments, listening to like 2-hour-long oral arguments of the cheerleader case, the free speech cheerleader case, which she ended up winning 8-1, and you guys did phenomenal work. And that's where I even learned that you could catch these things on audio. I was like, wow, oral arguments on audio, that's phenomenal.
Yeah.
And I become addicted. I loved your work, and I became addicted to that source. Yeah, and I was like, that was just such a phenomenal idea to hear lawyers weighing in on what justices were thinking and how strong each attorney was when they were presenting their arguments in favor of their respective clients. So,
well, thank you. I mean, I wish I could take credit for the idea. I think that was Uncivil Law's idea, but yeah, that was one of my favorite streams that we've done, or that I've done anywhere so far, because it was so much fun, especially at the very end. The what is it? The school district's rebuttal at the very end was just where she just completely imploded. That was
she crashed
that was electric.
She crashed and burned at the end there. It was pretty funny.
Yeah. Yep. So yeah.
Well, perfect. And what law do you practice? Mostly contract or just everything?
So most of my experience has been in litigation, either in employment litigation or trust and estates. Now I've mentioned to you separately, but I'm living overseas, so I'm doing a lot of contract work, doing mostly research kind of stuff for actually a legal tech AI company, which is super interesting. So basically, yeah, teaching AI robots how to do legal research is pretty cool. So
of course, I'm going to have friends of mine cringe immediately, say it's not AI, it's machine learning.
Well, okay, sure.
No, I mean that's an old thing with nerds, but it would get tired of. It's like everything AI is the hot term, and it's like,
yeah,
not exactly.
All right.
So it looks like the chat is dictating where we're going to start, and of course, it's obvious that Viva Frei is anti-Trump. He's a shill for Biden, and he wants to hold up all the social media companies. So explain yourself, please.
Well, first of all, I didn't hear the first 2 minutes of what happened because I couldn't figure out where the noise was coming from on my computer, so I had to turn my stream off. I had a window up that was the stream itself. It's an interesting thing. I'm looking at E. Clark's comment. The second someone says something that other people disagree with, we we attack the intentions of the individual as opposed to the arguments. And I'm saying this with peace and love. It's just the way people react to things. I want more than anything for big tech to be held responsible for what I think is overt. If it's not political censorship, it's at the very least narrative censorship, and for preferential treatment of certain people versus others. But I read the Trump lawsuit, and I think most lawyers, left and right, agree that the lawsuit itself raises arguments that have already been adjudicated upon. And as far as the state actor argument goes, it's weak on the evidence. I mean, tweets from politicians that say we would really like for Twitter to, shut Trump down, or we don't think Trump should have a handle. That, if that satisfies the threshold to cause something to become a state actor, if they do something at the same time without necessarily any direct correlation, okay, so be it. I don't think so. But it was fun to read, quite fun for Trump to praise his own social media skills and rub it in the face of everybody. But the lawsuit itself, I think, is going to lose. But maybe it makes a point nonetheless.
Alita, do you have any idea on it, or have you read up?
Yeah, actually, so literally just about 15 or 20 minutes ago, I published a video on the same series of lawsuits. And I concluded basically the same thing, that I think all of these lawsuits are not likely to win. You know, I was even looking at it from a class action perspective. Just the way that they were pled was actually not very good. There were no elements that were alleged that are required under federal requirements for a class action case. So something tells me that this lawsuit may have been, I don't know if it was rushed out the door, or if it wasn't actually trying to actually make it as a class action lawsuit, or if it's just more of a political statement and, you know, a way to get his name out there, get him back in the legacy media, so to speak, you know, get people talking about him again. I don't know, but I basically concluded that I agree. I don't think these lawsuits are likely to go anywhere.
And Joe, same basic question for you, but also to tag on, I want to roll forward too. I personally feel what's happening in India, for example, to Twitter, may actually have a longer term effect in making things change. And I'd love to know your opinion, obviously, on the lawsuit and what you think about Twitter bleeding a little bit.
Okay, so this lawsuit is against Facebook, not Twitter. Okay. I spent 2 hours streaming. Now, it's the same thing, you know, as far as going after big tech. I just wanted to be technically accurate. So, yeah, I spent 2 hours going through this, really for the first time with my audience and reacting as I was reading it. And I had a ton of thoughts that I'm going to try to wrap up in like under 3 minutes. So, as I believe Alita mentioned, there are 4 different elements that you need to establish under Federal Rules of Civil Procedure Rule 23, which was what governs class actions. So you need to establish that there's numerosity. That I think there's not a problem with. The other 3 elements, I think they're going to have problems with all of them. There's commonality, there's typicality, and there's adequate representation. The one that stares you in the face and says, "What are you even thinking?" was your typicality. The third one I mentioned is that your client, your plaintiff, has to basically be representative of everyone else in the class. That there's you start with commonality and say, okay, there's certain certain features which are the same to everyone, and wrongs committed by the defendant or allegedly committed by the defendant, which are wrong for all of these numerous plaintiffs. And typicality is saying this lead plaintiff that we're mentioning here is typical of all the other plaintiffs. And then they spent 30 pages going on and on about how Trump is really unique and completely different from any other person, which is shooting your argument in the foot, because you're basically saying he's as atypical a plaintiff as we could possibly find, because he's being treated differently than any other human would be treated because he's president of the United States, because he's not able, it's affecting his ability to run for president of the United States. I was reading it and sort of laughing and saying, yeah, he's a typical plaintiff. Both he and I, when we're censored by Facebook, neither of us are able to run for president now. I mean, think about how silly and ridiculous that sounds. Even number 4, adequate representation. If you look up the law firm, and they seem like, you know, a nice law firm, I'm not knocking any lawyers there. They don't bill themselves as class action attorneys, which is what you expect to see when a plaintiff is alleging that they're able to be certifiable as a class, in that they meet all 4 elements. They seem to be strong writers. I happen to appreciate their writing style. And I think so I think there's a lot of problems with trying to label this a class action suit. On the other hand, and I've never tried doing class action, I certainly would not be deemed adequate class action representation because I don't do it. And the reason the court requires it is because they're trying to stand as a proxy for thousands, hundreds of thousands, or as they claim, 1 million potential plaintiffs. And the court wants to feel confident that they're going to be adequately representing their interests, and that they're going to be handling all the procedural elements which are unique in a class action suit properly. So these are all the problems with class action suit. I don't think that this case is as terrible as Viva was implying, in that I think they were bold in going after Section 230 and specifically addressing a change in Section 230, which I don't think we've seen that. And I think that the Rogan O'Hanley case that the Dylan Law Group brought against Twitter has raised a lot of questions as to whether the social media, by creating its own bat phone between Democratic leaders and social media, has now strayed onto the field of basically being an arm of the government. So
here's the thing on that, though.
Yeah, go ahead. I'm sorry. I've been rambling for a while, so you can.
No, that's fine. That's the thing is, there's two things. First of all, just going after Jack Dorsey personally in the Twitter lawsuit is weak, because I presume you have the same corporate veil principles in the United States, and in order to pierce the corporate veil and go after the executive personally, you have to allege meaningful personal interference in the allegedly wrongful act. And in the Twitter lawsuit, it basically just says CEO, he was the CEO when he made this decision, therefore we're throwing him in. So
you mean Facebook? You're talking about against? I didn't read the Twitter lawsuit. I was talking about the Twitter.
No, I know. Well, it's the same principles. I'm only talking about the Twitter lawsuit, not the Facebook one. The Trump and class action against Twitter. So they threw Jack Dorsey in there just with two weak allegations that the decisions were taken while he was CEO. Fine.
By the way, if you didn't read it's good. You read Twitter. I read Facebook. They did the exact same thing with Mark Zuckerberg. I was screaming yesterday. There's 0 point to bring in Mark Zuckerberg.
Yeah,
so please continue, because I'm totally on board with this.
Yeah, well, that's it. Even in the best of circumstances, you need to have an overt, deliberate act by the principal of a corporation to bring them in personally to pierce the corporate veil. So setting all that aside, I forget what the California lawsuit was. No, the one you did the live stream on, which talking about receipts of coordination between politicians and big tech. Right. That is lacking from the Twitter lawsuit, because in the Twitter lawsuit, Trump class action versus Twitter, you have a paragraph, or it's basically a page and a half of statements politicians have made on social media in interviews saying, threats of eliminating 230 immunity. They don't like Trump using Twitter, yada, yada. That is, I imagine, I'm fairly certain, based on my limited understanding, is insufficient to create the Marsh v. Alabama state actor of a private entity. And so it's good. It raises interesting points. I think it's brought up to create this as a policy issue come next election. And I think that's the strategic point in all of this, is the lawsuit's going to lose, and therefore it's going to become an election issue, much in the same way the wall became one in 2020. So I think that's the ultimate purpose of this. But it's not, because one can look for intentions to attack why I think what I think is what I think, but it's nonetheless what I think is the case.
And to follow up on your point, by the way, I think here's what's so troublesome. I do think that you can try and go after Section 230. I think this lawsuit could have been stronger. Don't try to make it a class action suit. The whole idea of class action is that all our cases are the same. We all were advertised with a class action suit. Typical case I explained to my audience last night is you have a refrigerator that they advertise as 33 cubic feet and it's 31 cubic feet. All the people who bought it are victims of this false advertising. They should have paid less for it. It's quantifiable. You can figure out exactly what went wrong and how much they were damaged. When you're talking about a situation like this, where every person, I've been wronged by social media, I've been harmed by social media, so have probably each of us. You've been demonetized at times you shouldn't have been demonetized, but each of our stories are different. So it makes it very hard to argue as a class action, because the whole point of class action is we've all suffered wrongs in the exact same way. And yes, I understand it's an overarching theme that we're all conservatives, but the nature of how they've attacked us has been different. And amongst those who have been attacked, some people are really genuinely bad people. I mean, real criminals who are they might have a sign that says, MAGA 2020, Trump 2020. And at the same time, they're engaging in criminal activity with children that would horrify all of us. So, so many of them who are saying, oh, I was just brought under this whole bridge, are genuinely bad actors who you wouldn't want them under the same, characterization as you and I. So that's why I think the whole notion of class action here is very poor. And what's really bothersome to me, and this reminded me of our debate about Giuliani, and I'm not going to go into the details of that, but one of the things that's so frustrating is when you have real claims, which I think happened with Giuliani and all the issues that he's facing, and I don't want to use it, an F word and get, all of a sudden we go into the red here, but when you have real claims and then you throw on other specifics that you cannot substantiate, that just rally up the base, may be true, may not be true. You take those real nuggets and you bury them in just this mass of cow pie that your detractors will say, well, you can't prove that. That's garbage. And the same way you can't prove that, let's assume the rest of your arguments are garbage. And that's what frustrates me about bringing in Mark Zuckerberg and Jack Dorsey, where you're basically muddying your own claims for no benefit and no reason. And making a class action, you're muddying your legitimate claims about Section 230 and that we need, the court should look at examine whether Section 230 should be changed. And you're making a potential pearl of a great claim into a claim that all your detractors will easily be able to attack for other bases, which just makes your whole claim look like garbage. And there's no need for it.
And from the peanut gallery, we have Nate the lawyer joining us, not showing his face so he can snipe.
I was supposed to say that Nate's internet was out, and then I didn't get to say it yet. So Nate, welcome.
Yeah, I'm no camera because my bandwidth is like cell phone bandwidth. So it's either this icon or nothing. So how's everybody doing today?
Awesome, good, man.
Well, Nate,
Hey, Nate.
if you talk with a low voice, you can pull a doomcock and just become the lawyer of the underworld. But jokes aside, I just want to, Eric, can you bring up E. Clark's comment? Viva, you don't think that Dorsey and Zuckerberg conspired to ban Trump, or that his banning on Facebook and Twitter at basically the same time was mere coincidence? I have no doubt they worked together and in collusion and conspired or coordinated. No doubt. To go from there to say that they become a state actor because they conspired with or at the direction of the state is another issue. And whether or not I believe that, the question is whether or not the allegations in the lawsuit are sufficient to evidence that. It's not a question of what you believe. Go to court and say what you believe. If you don't have the evidence to back it up, you can believe all you want, and what you can believe can be right, but you still can't prove it.
Yeah, in law school, though, my professor used to always say this: it doesn't matter what you believe. Matter of fact, it doesn't matter what you know. It's what you can prove in litigation. If you can't, no matter what you know, I know OJ killed those two people, but they could not prove it, right? And that's what it's about. You can say they conspired. It looks very suspicious, but just saying that on the internet and just saying all these things happen, unless you can prove what you're saying to be true, you have nothing. You can't win in court. It just is impossible.
Well, I would also have, and then the collusion between the big tech might be an antitrust argument, but not necessarily rendering them a state actor argument, which is the basis of this lawsuit. So the antitrust.
Well, let's try. I just want to ask you about that, Viva, if I can for a minute, what you just said, because I'm not sure I agree with that part of it. The collusion between Facebook and Twitter, that would be an antitrust issue. When it's collusion between Facebook and government actors, Facebook and Mazie, Hirono, Facebook and Adam Schiff and Nancy Pelosi, or, Twitter and Jerry Nadler, whatever it is, that is now something that I think is what leads to a state actor as opposed. I don't think that would be antitrust.
No, that's exactly what I just said. Good logic. That when the alleging the conspiracy or collusion between Twitter and Facebook might be antitrust, but that's not the basis of the Twitter lawsuit. And they didn't allege any overt collusion between politicians.
Oh, I'm sorry if I misunderstood. I apologize.
But now, LegalBytes has to say something. Your mic is on mute, but you have to unmute it when you want to talk.
No, I know. I'm enjoying hearing what everybody has to say about everything. I definitely agree. I think that the the collaboration, you could say, between the government and between Facebook or Twitter or Google, that has been shown through the Fauci emails and all that kind of stuff. Like, it's very clear that, of course, there was collaboration between them to create this, this information hub for COVID-19. They said that they wanted to prevent, misinformation. None of those are at least on their face evidence of any kind of an intent to abridge anyone's constitutional rights. I mean, if there's more evidence that shows, we want to target people on the right, or we want to target people, based on specifically what they're saying, aside from the general, like, we want to try to prevent any sort of misinformation that's being spread around. I mean, obviously that justification can be used and probably has been used. Many people would think that it has been used on a lot of people that have that lean more conservatively in terms of banning them from social media platforms. But But basically, I don't think that that what's in those emails is exactly enough. Now, there could be more that could come up in discovery, but if this is what's there and that's it, beyond the redactions that are on those emails and whatnot, then I just don't think that it's enough to show that there is a conspiracy, collaboration, not necessarily rising to the level of a conspiracy.
Well, you know what? I think it would help the audience if we actually looked at the test for being a state actor. I sent it to Viva. It's called the Edmondson Luca test. It was written by Justice Kennedy, and it was a test to show exactly how a private company becomes a state actor. The test has 2 elements and 3 factors, and it lays it all out. And so, and I think it may be helpful if those who are not lawyers can see the hurdle that someone like Trump or anybody else has to get over when it comes to state actors or becoming a state actor.
Nate, you had sent me the screenshot, and I was gonna get into it in my video yesterday, but it's nuanced to the point where only someone interested in the actual, the fine points of the law would care. But the bottom line is there is a threshold that needs to be met in order for a private actor to be deemed to be a state actor. Some people in the chat saying, getting protections from the government, doesn't that make you a state actor? No, every corporation gets some sort of protection from the government, or they get some sort of government, won't say protection for lack of a better word. They get some government recognition. It really, to become the state actor, there's a threshold, and it requires a certain evidentiary burden, which there is one. But the Robert
isn't it incidental? Like they could be a state actor with a particular incident versus an overall state actor.
Yeah, but all right. So if I can, I'll go over some of the cases. One, the most famous case that everybody tries to get social media on is Marshville, Alabama. The company town. So let's say the company town. All of American lawyers should know company town, Marshville, Alabama, and that's where a company owned a town, and it was no different than any other town. They had police, they had sewage, fireworks, everything. And the Supreme Court said, well, if you're running a company town and it's just like any other town, and you're doing sewage and police services, then you're going to be held to constitutional standards because there's no way to distinguish this town from any other town. So obviously Marshville, Alabama, and that stands for the proposition of the public good, right? Electricity, for instance, things of that nature. You can't if my electricity company is the only electricity company in New York and say we're not going to give services to Black people or to conservatives, that would be illegal because they would be considered that's a public function. That's Marshville, Alabama. And the second one is I think it's called Burton. It was from Delaware, in which there was a coffee shop that did not serve Black people in Delaware. And what happens is that one of the patrons, who happened to be Black, sued the coffee shop and said, hey, you can't discriminate against me because I'm Black. And the coffee shop owner was like, listen, I'm a private company. I can discriminate against who I want. But the catch was that private coffee shop was in a parking facility that was owned by the government. So this person had a lease with the government in government facility on government land. So the Supreme Court said in that particular case, because that coffee shop relied on the government, right? They're on government property, leased with the government. Then in that instance, they're so entangled that they couldn't discriminate, and that was Burton. And then you had there were a couple of other cases that kind of with that same reasoning. Now, incidental contact or incidental things doesn't make you a government actor. You have to kind of overcome this where you would, like, say, for a police officer, if I as a police officer tell an individual to go search a car, then that person is working on my behalf, and then that person would be considered a government actor, and that search would be considered a search on behalf of the government if I direct them to do something like that. So it's never really a clear issue on whether something's a government actor or not, but the courts tend to be they tend to likely not find that things are government actors than to find that they are government actors. So you really have a higher burden if you're trying to say a public entity is a government actor. That might have been a bad explanation, but that's it.
That was a phenomenal explanation.
And in the Robert F. Kennedy lawsuit, which was just dismissed at the lower court level, I mean, the evidence there was stronger than the evidence presented in the Trump Twitter suit. And the judge, and I don't necessarily agree with the judge on this, because the judge basically said, yeah, there was coordination. There was mutual collaborating. There was mutual discussions, internal emails, but there was no compulsion or coercion from the state requiring Facebook to do whatever, which does not bring Facebook to the level of a state actor for the purposes of its First Amendment violations against RFK and the Children's Health Fund or the Children's Health Defense. So you already have that precedent out there. That one will probably go up to appeal and will set a meaningful precedent that might have an impact on the Twitter suit. But the evidence in the Twitter suit or the allegations are already weaker than the allegations, which were stronger in the RFK versus Facebook, which was already dismissed.
I will tell you, I tried to pull a comment up earlier that I think is, here we go. Kind of ties in, but it would be good to readdress it. And because I don't know that if this is a take I agree with. The comment is the basis is that 230 provides protections that kind of make them a state actor. It's not the collusions. Well, I don't really agree with that on 230. So can we just visit 230?
Well, even without that, there's a principle of general applicability law that's generally applicable to a mass group, right? So, for instance, taxes, right? We all pay taxes. So just because I pay taxes doesn't mean I'm a state actor, and just because 230 says you can do this doesn't make anybody who's subject to 230 a state actor, because the law is generally applicable. When it does come to state actors, you're talking about, for instance, the 9/11 compensation fund. It's run by a private organization, but there's a state law that specifically gives the 9/11 compensation fund the authority to operate and to receive these funds. So that legislation that specifically gives them that authority makes them a state actor, even though they're a private, not-for-profit corporation. The same thing with the Federal Reserve. The Federal Reserve is a private corporation, but could be considered a state actor because it has specific legislation that gives it, they act under state authority. And so 230 does not, just because 230 is there, doesn't make Facebook and all these, because you're essentially what you're saying is that every internet site that can rely on that has immunity based on Section 230 is a state actor, and that's just not the case.
Okay, so let me, you know what, I'm going to try and, at the risk of endangering my law license in the state of New York, I'm going to try and play co-counsel here for Trump. And I'm going to make the point that I agree with you that March v. Alabama doesn't apply here. And the reason it shouldn't apply is, if you think about it, just break it down. March v. Alabama is basically saying you are becoming your own government. You're becoming your own state. Once you become your own state, you're governed under the same laws as the state. So that's not what happened here with any of these social media. The argument that I think perhaps can hold up is that since they're given protection, normal protection that every other industry does not have, they're given this protection as far as you're not subject to becoming a publisher. You'll stay in your distributor status because Congress has conferred upon you this special blessing of you are always a distributor, no matter what you do. And even though the language says as long as you're addressing abuse or violence or harassment or sexual content, and then throwing in that otherwise objectionable, in theory, now Congress has conferred upon them a right to basically do whatever they want. And it's been interpreted as them being allowed to do whatever they want, because case after case, Section 230 has been a perfect shield for social media. So by conferring upon them that special blessing under 230, I think that you can make an argument that what other private agency has that blessing? Where do you have a situation? I mean, and I'm
alcohol. There's
what special blessing does the alcohol industry have that as a private agency they're not subject? They're able to basically abuse the First Amendment.
Well, not abuse the First Amendment, but for instance, the Constitution and prohibition. So for alcohol, for instance, they are heavily regulated. To even sell alcohol, you have to get licenses and everything, and it's even more regulated than this social media. And there are actually some immunities involved in, if somebody dies of alcohol poisoning, for instance, how many alcohol people, or even with the gun rights lobby too, when people get shot by guns, the gun manufacturers are immunized in most cases from that harm. So it's, if the argument is that some industries have immunity, like even in the healthcare industry, right? There's immunities with Obamacare, for instance, where you couldn't go across straight lines and stuff. And on top of that, even some doctors, you couldn't sue some doctors. It was a famous Supreme Court case that went 9-0 where you couldn't sue the healthcare industry. That would make you essentially would make all healthcare providers and all health, would be state actors. The railroad companies would be state actors, all liquor licenses, because again, even though I understand you're giving them this privilege, but it happens so often over so many different spectrum, then it seems like everything would become a state actor.
Well, yes and no.
I know we got a break for LegalBytes because whenever she unmutes, we hear the noise, but when she talks, when she's unmuted, there's no noise, and it was off for a second. So.
I know. I'm so sorry. I haven't actually heard this noise that everybody's commenting about. So I that makes me think it's probably me. Unfortunately, I'm so sorry about that.
It goes away whenever you go on mute. It's just the background.
It's me. I think it's me because my thing is on. So
it was here before you. It was here before you were here, Nate.
Yeah, it was here, but I'm pretty sure it's me. That's very kind of you, Nate, but I'm pretty sure it's me. Yes. So I'm sorry. I've been a little bit distracted for the last few minutes on that. But what you guys have been saying about the incentives related to legislation related to Section 230, the fact that doesn't necessarily automatically give turn these companies into state actors, I believe is correct, because there's even more examples of the government giving immunities recently, which was the COVID legislation. Didn't they grant a bunch of immunities to small businesses for having people go back to work?
Nursing homes. Along that line, nursing homes got under COVID. They got special protections, like in the state of New Jersey. They passed a law which basically said that even if you completely messed up and it caused your residents to die, you can't be held accountable because COVID is such a novel thing that we don't know how to handle.
Right.
So you're correct in that.
So those nursing homes are not suddenly state actors just because of that. I mean, there are all kinds of laws that have existed since the beginning of American history where people have gotten incentives, so to speak, from the government through various points of legislation, and that doesn't mean that they're state actors.
Yeah, but I will question this. Look, I'm trying to find a ground here, so I'm just want to flesh out what potential way that they can sort of get in here. Even though I'm on board with all of you that I think that this case is ultimately a loser. Unfortunately, I wish I could say otherwise, but do any of those abridge First Amendment rights? Because we do have broader scrutiny to try and protect First Amendment rights, and I can't think of any cases or any examples where someone has immunity. I mean, Nate's correct. There are countless cases where special immunity is conferred by government on private industry, but for them to confer an immunity, which enables, here's the thing: there's two elements to it. They conferred upon them this immunity, and then used social media to restrict free speech. So it's really those two steps combined. First, the state says, don't worry, you can't be held liable for abridging people's free speech. And then the state says, and we're going to tell you who's free speech to abridge.
No, it just takes
so those two together that could theoretically, especially because it's First Amendment issues, that theoretically could be held to throw some shakiness on Section 230, I would think.
I think it was the erroneous reading of 230 from the beginning. It did not give them immunity to censor free speech. It gave them immunity in the event that they failed to remove something from their platform that was illegal or otherwise objectionable. Objectionable needs to be read with illegal or whatever the other terms were. So it's just an erroneous interpretation from the beginning. It takes one good case to clarify at the Supreme Court level what immunity Section 230 was intending to give. It was not intending to allow the platforms to do whatever they want in terms of removing. It was intending to give them immunity in the event that they failed to remove something that was illegal, defamatory, or otherwise objectionable.
Although that's actually not the full paragraph of what it says is because Section 230 also protects them in affirmative moderation of their content too. So it's not just leaving content up that is maybe objectionable, but it's also taking content down based on their terms of service and their policies.
And I also think. Well, I'm saying. Go ahead.
Okay. Well, from what I understand, it was the Prodigy case with bulletin boards, and what was happening was. When they were not doing anything, nobody could really get a hold of them. And then they started to selectively take things like CP off of the board or whatever. But because some things were left up and some were not taken down, they were getting slammed because they did start to monitor the boards. And that's why Section 230 was put in, is actually kind of to cover both, that they're trying to make a goodwill effort to take off criminal things from the boards. But they can't be held responsible for everything. So it did give them the cover to take things off. And you can all correct me. That's how I understand it.
The issue that I'm coming up with is that I think we've muddied it so much that we've forgotten some of the key principles here. Number one, these companies never had to follow First Amendment protections, right? They never had to give any, even with let's say if 230 was gone, right? Still, they would still be able legally 100% to censor whatever comments they want. We can keep these up, pull these down, right? So this is not an immunity from First Amendment, because they never had to follow the First Amendment. They're not state actors. We just had that conversation. So the second piece I think we're all confusing is that the immunity we're talking about was from defamation, because if you put something on that was defamatory, then they, as a third party, the publishing versus publisher versus whatever
distributor
platform. So understanding that piece of it, when we say Section 230 gives immunity, we're not saying it gives immunity for the First Amendment, right? Because they never had that was never the issue. It's against defamation. So now if you were to remove Section 230 protection and allow them to be sued for defamation claims in this particular, that's one issue. But in Section 230, when it comes to the First Amendment, that's a misnomer. They are not protected, they are not immunized because they never had, the First Amendment never applied to them.
And that's where someone had made a comment. It said they're using government infrastructure. I can't find the comment. Either way, the statement was that they're using government infrastructure, the internet. And so therefore they should not be allowed to censor, even if it's not a First Amendment violation, even if they're not state actors. And that's where I personally think the stronger argument is to be made, that these should be deemed to be utilities or utility-like in the way they are used now for the public dissemination of information at all levels, from the government down to individual free speech. And they should be treated in the same way that phone companies would not cut calls because they don't like what people are saying, although they could be tapped if they're saying things that are illegal. And so that's where I think the stronger argument is. And it's right. Nate's saying they're private enterprises. They would have always been able to remove objectionable content. They would not be able to censor or discriminate based on protected reasons, but they could remove content that they don't want on their platforms. And it would not have been a violation, even in the absence of immunity.
Well, phone companies.
I've got to get these comments. I've got super chats coming in that it's like, okay, you're gonna give me $100 super chat. I'm going to interrupt.
Yeah, you got to read this. You got to read this.
So, sorry, everybody, but priorities here. I'm learning from Makeda. Got to get the grift. Nate, and this makes it even more fun. How can you reasonably make the argument that a gun maker can be held liable for the gun functioning properly? Even if a maker sells directly, they have to obey FFL documentation requirements, which forbids selling to felons, and they have to list the names and ID of buyers. I would think anything manufactured, you could be held liable for.
Well, I maybe one thing I know there've been some cases with gun manufacturers, for instance, like where the gun manufacturer has a gun that's easily modified to make it from what's it called, from semi-auto to auto,
automatic, or first mode to fully automatic,
and it seems like, and so somebody will do that and then have a mass shooting. So then the families try to sue the gun manufacturer. This actually has happened a couple of times, even in Sandy Hook. The Sandy Hook families tried to sue the gun manufacturers after the children were dead, and they were unable to do so based on, I forgot the law, but they, this always has a problem. Whenever you have these mass shootings, generally the families try to sue the gun manufacturers, and they're not allowed to do so because it's just, after you sell the weapon, the gun manufacturers can't be held responsible for what the person does. So that's the type of immunity I'm talking about. But it's not a state statute. There are other examples. If everybody's hooked up on the gun example, for instance, the example of healthcare. There's healthcare companies have an absolute immunity under Obamacare, right? So there it is. And there are a whole bunch of other ones too.
What was that currency, Eric? I've never seen that squiggly line before.
I don't know if I don't know. I don't think it's Indian rupees, but I'm not reading this out loud. I acknowledge it, but I'm not reading out loud. There's words.
It's a metaphor. It's a metaphor.
Of course it is. But you know what? The algorithm no sense of humor or irony, and I've already had my channel vaporized once. I don't need to.
Rupees is the answer. What were we?
Sure.
But Nate, we had discussed this also. Oh no, go ahead. You got to read the chat.
Yeah. This continues on with what Nate is saying anyway, so I mean it's right in line. Nate misunderstands the firearm manufacturer's immunity. It's not special immunity. It's because the manufacturer is being sued for wrongful use of the product. I think we kind of just said that.
Yeah.
Car manufacturers aren't sued when someone's drunk driving and kills someone.
Let me defend Nate. Nate did not misunderstand anything. It might have been misunderstood or misspoken, but Nate understands the law, and Nate was not. Anyways, I'm defending Nate, but Nate understood what he was saying and the principle there.
Yeah, I'm trying to it's sometimes these things are difficult when you're trying to make analogies, but the core principle is that there are many companies or many different products that have these immunities to them where you can't sue. And insurance companies are one of them. For instance, insurance companies can't be sued if they deny your claim. That this is, but they are not. The
specific example: COVID vaccines. They've been given immunity for the EUA or EAU vaccines. That does not make the pharmaceutical companies state actors. Period. So certain benefits do not make them state actors. Coordination, discussion among does not make them state actors. The threshold that you have to have, and using Marsh v. Alabama, even Dershowitz used it yesterday in his interview with some British Airways. British television. It's not the proper application. It's a totally different thing where Marsh v. Alabama was an entire private company acting like a city, and this would be punctual state actor compulsion, even if the evidence were there. So not analogous, but there is a threshold that has to be met, but we'll see. It'll work its way through courts. The problem is people think they'll get to discovery and they'll find all these emails. As a Canadian lawyer, I was shocked at the amount of lawsuits in the States that get dismissed at a preliminary stage. In Quebec, you file a lawsuit, if there's the slightest iota of legitimacy to it, the courts are never going to dismiss it before a final hearing on the merits or, patent frivolity being demonstrated. In the States, I was flabbergasted. They get dismissed on summary judgment, on motions to dismiss, Rule 12b4, 12b6, whatever, all the time. So you don't even necessarily get to discovery to hope to find the emails that you think you need to support your claim.
Can I just take a moment to point out how Nate is a cash cow for Eric here? Because he gets people riled up enough that they're like, no, I need this comment scene where I'm coming after Nate and it's going to be read out loud. But at the same time, not riled up enough that they leave. So you are really the perfect, Nate, you're the perfect guest for any potential.
No, actually, I appreciate if I'm wrong on something, like somebody said, it's not special protection, but regular protection. And that's fine. If I'm wrong on the terminology, I actually appreciate when people correct me because I would rather go forward with the right information than wrong information. I know some people get touchy about it, but no, there's so much law out there that if I knew it all, I wouldn't be on this stream. I'd be making a lot more money.
You referenced the test earlier that I hadn't looked into. I'm actually curious about
Edmondson Luger test. It was written by Kennedy from the case. I think it's Edmondson versus it was a train company, I believe it was.
Luger.
But it's called the Edmondson Luger test.
I don't see how Marsh v. Alabama is going to help here at all.
It's not.
But Marsh v. Alabama, it's the test is it's one of the weirdest tests out there. It has two elements. The first element is, does the source of authority come from a state action? For instance, did the state pass a law? Was it a regulation or something like that? And then the second part of the test is a 3-factor analysis. And they use Marsh v. Alabama, Burton, and another, I forget the last case. And you're supposed to take your facts and see if they match it with these factors. So it has factors, it has elements, but eventually, but at the end of it, you make an argument to see if you're a state actor or not.
I hate the word shills. Okay, I think we spent a lot of time on this. Can we get into the January 6th detainment? Because I don't understand how there are still people being detained. Avenatti just got sentenced to 2.5 years in jail for extortion. And meanwhile, we've had some dude spending 6 months in pretrial detainment for, what was it? I mean, interrupting government proceedings.
He's almost a prankster. I don't, I would not take him to the full degree of the label that they've put on him. I haven't seen any footage of any kind of vandalism or anything else. And yes, I'm tap dancing like crazy to not name which incident it is, but it's a gentleman who has a strange dress code and face paint mechanism who's sometimes on magazine covers.
People refer to him as the shaman.
Yes. And apparently he incited an erection with Schumer, so.
I'm not even going to say the first part, but just the shaman. And you can replace the word "the" with a letter with like the 18th letter.
I missed it, Alida. Alida, what jurisdiction are you in?
So I'm licensed in California and DC.
Ah.
Two of the craziest districts in the states.
I know, right? It's crazy.
You notice how everyone like we're all like you're from Canada, Nate and I are from New York, and we're from like the ones in America. We're from like the most liberal parts of America. I mean, I practice in New York and I live in New Jersey. Nate's in New York. You're in California and DC, which is just like a double dose of wow.
Double dose of double taxes.
But that's where all the work is at, baby.
Yeah.
Although I did go to law school in Texas, so I'll claim a little bit of Texas with my resume.
Oh yeah, the big question I haven't stated. Yes, I went yellow the second I hit the monetize button.
You know what? Somebody told me that comments actually can send you yellow on a live stream.
I've been told the same thing. I know. I think it's just Eric is on the naughty list for a while. He gets green lit afterwards, but it's
Yeah, they make sure that all the trajectory, all the volume, it's like okay, he's not gonna get many more views. We're going down the trough. Okay, we'll monetize it now.
The same thing has happened to pretty much all of my recent live streams as well. It's pretty annoying to be like, oh, okay, well now it's okay. Now I can make money from it. Now that no one is left to watch it, right?
Yeah. What has two thumbs and makes Susan's toes curls? This guy. So.
I don't even. No, I that can be interpreted in a number of different ways, but
many different ways.
I know we're going to be getting into fingering criminal.
Oh my gosh!
Again with him.
It was a reference. It's a real pop culture reference. What's wrong with you people?
But is it because I'm going to show my naivety. Is it a sexual or is it a cringe?
No, no, it's from The Office. The guy like Packer, he was like the cringiest, most annoying person, and like he would tell all these jokes, these stupid lead-up jokes, which would start with "what is two thumbs" and whatever, and then he would just like point up to himself and say, "This guy." It's a pop culture reference. How am I the only one who knows this? It was like the most popular show.
It's not
of like
that pop culture.
Well, all right.
More like pops culture anymore.
Oh, please.
The boomer joke right there. Boom.
Really? The Office?
Hey, I get made fun of all the time too, man. So I just spread the wealth. I got to bring Anton for a reason.
You're welcome.
No, I love The Office, but I must have missed that episode because I thought I saw it until the very end.
Packer.
But it's been a while. It's been a while. So
he's like one of Michael's best friends. He comes onto the show. Everyone in the audience, I'm sure, knows that.
Yeah.
Well, whatever. An Xer. Okay. Well, there you go.
All right. Somebody's saying it's also in Scrubs. Bob Kelso. I never really watched that. Okay. So what other case? We talked about Britney some last week. I know that Nate and Elite, I believe, are up on Britney to a degree. Can't answer for David and Joe, but
I just saw what Madonna said this morning in support of Britney. And with support like that, you might just want people to not support you, because when you start talking about DEATH to the patriarchy for what's being done to Britney, that's the type of support that actually is the type of support that certain presidential candidates had, and it can compromise the perception for the rest of the world. If anybody didn't hear what Madonna said, it was posted on Instagram. Fox News referred to it as unhinged. I would say it was about as unhinged as some of the things she had said previously in the election cycle. But she's at least bringing awareness to what's going on with Britney. But there hadn't been much new news this week on this.
Well, actually, there were a few things that happened. Her attorney has requested to be removed from representation, and then also the Bessemer Trust, that's the co-conservator of the estate, so on the financial side, has also requested to withdraw. And then I think the other thing is that the Jody Montgomery, that's the conservator of the person, so for her daily care and her medical care and all that kind of stuff, she requested extra fees because she's been getting so many death threats and other threats of violence against her because of what's been happening lately with Britney Spears. So, I mean, I would definitely agree that Madonna's statements are probably not necessarily welcome, because those kind of inflammatory statements and any kind of threats towards these people are only going to cause them to spend more money on security, and all of that money is going to come from Britney. So I I'm pretty. If you are Team Britney, Team Britney, free Britney, probably sorry, what was I going to say? I was getting a little bit distracted again.
Well, no, don't say things that are going to cause more backlash, which will make it more difficult for the petitioner to obtain that which she wants.
Well, I mean, but yeah, exactly. So what I was going to say is that, if you are Team Britney, probably, calm some of the emotions a little bit. I know that people are very upset and they're very emotional about it, but yeah, I don't know. Threats of violence are probably not a good idea.
I think this is one of those public relation things where the public relations piece is great for Britney, but what's the reality? It's like the U.S. women's soccer team. It's the same thing. It's like there's a public relations side to it, but then there's a reality to it, right? They got paid more. And I think this is kind of the same thing where the public relations side is, hey, this woman is being held captive in a conservatorship. Oh my God. But then the reality is you got two different judges who've seen all this evidence, who still continue to put the conservatorship off, who've heard what she had to say, and they still continue to do it. There's a hearing coming up on the 14th. And I understand, it's easy watching things behind the screen and saying, free Britney, right? But no one knows her medical condition, right? No one knows what these doctors are saying that have convinced two judges to keep her in this conservatorship. And until that, I think until we get that evidence, until we actually see what's going on, then you can make a more informed decision. I think, this is great for Madonna to say that, but she could actually be putting some, that could be actually doing harm to Britney. It could be doing something against medical advice, because if you don't know all the facts, you shouldn't be advocating for a position. And that's essentially what we're doing now. That's essentially what cancel culture is. When the girl is about to stab the other girl and the cop shoots her, the PR is evil cop because it shot a black girl. And no one hears about, well, she was about to stab someone else. You know what I mean? So I'm hoping we eventually get all the facts. But right now, based on the facts we have, I'm just not sure. I was Team Britney, but until I know what exactly those doctors are saying and why these judges with an S, continue to keep these conservatorships on, then I'm agnostic to it.
I want to see independent third parties. So that's all I've been saying, is I would like to have somebody disinterested come in and just look at all of it. Both doctor, legal, people who are not on her payroll. I mean, of course they will be ultimately, because everybody seems to be, but just people to come in. I don't know what you would call them, but somebody who both sides can agree with is, has the credentials and whatever, do an evaluation of the case, the legal side, and do an evaluation on the medical side. And just,
do we know that's not happening? How do we know that's not happened yet?
Well, so I was actually just going to say, I mentioned before that I did litigation and trust and estates. I did work on some conservatorship cases as well, and that's an essential part of any conservatorship case is that the judge has a third party evaluator come in that is appointed by the court, so they're completely disinterested in the case, and they come in and take a look at the potential conservatee. They talk to them. They talk. I believe they also talk to the potential conservator as well. But they come in and they actually do an evaluation. I don't know how long it's been since there was an objective evaluator in this particular case. Maybe it's time to have that happen again. But I know that's an essential part of at least establishing any conservatorship case. Well, but one of the things that Britney said in her statement to the court was that she wants to have the conservatorship end without an evaluation, which I don't see how that's going to be possible, because that's generally not how things are done.
Here's the thing. Lawgic, you want to go?
Well, I just want to point out, with respect to getting these independent assessors, there are two ways that the courts can approach a situation, or I've dealt with in litigation. There are two completely opposite ways that they approach when they're trying to make an assessment about a situation. You can have, medical experts testifying for, and then medical experts testifying against, and then it becomes a battle of the resumes and who's more compelling as a witness to make their case. That's one way that courts tend to approach it. A second way that they'll approach it is that, especially when it's not held before a jury, is that the judge will direct both sides to come up with the name of one person who will do the examination and will give an advisory opinion as to what they think the state of the matter is. And frequently they'll say to, they'll say to plaintiff, you give 3 names or 5 names that will work for you, and the defendant will pick from those 5 names which one they want to choose, and then that person will do their assessment of the situation and then render their professional opinion. And that way it's not, first of all, that's to save money, because Britney's paying for both of them. She's paying for her dad's stuff, she's paying for her own stuff. I mean, if you know Britney and you're not on her payroll, you're just not trying. But more importantly, like this way, you sort of know when all is said and done exactly, instead of it being 2 sides fighting against each other with Britney paying for both of them, you have one mutually agreed upon side, which is an independent assessment, which is not going to be conflicted by anyone else, and that both parties have mutually accepted as being a voice that they will sort of trust on making this medical assessment. Now, I haven't looked at it. I don't want to mislead anyone and say I've looked at that happening in terms of conservatorship, but I have seen that in other litigation realms, and I cannot see why that would not be a possibility over here. And with that, I turn up to this guy over here.
No, I would only say that we're never going to have all of the facts, and so if that's if that's the element that's going to withhold people from taking a position, you take an attenuated position, but we're never going to have all of the behind the scenes facts. So that would be tantamount to saying I'm never going to judge what's going on here. This conservatorship, as just a pure matter of fact, for someone in Britney's situation, seems to have gone on for too long. 13 years is just prima facie too long. We know the break that she had in 2008, and so the fact that it's still going on now, prima facie too long. The fact that she's still working and working full time and hard, if she is as ill as it is required in order to have the conservatorship, then she should not be working. And something tells me that if the estate were not generating millions and millions of dollars, you might have people fighting less to maintain this conservatorship, because once you get money and lots of money involved, it corrupts everything and everyone. And so there's just a few elements that don't make any sense. Britney might have money squandering problems. That's not what the conservatorship was intended to protect against. It was intended to, at least this type, from what I understand, chronic, irremediable, degenerative mental disorders or mental conditions, not a break which has been long since stabilized. And
which is weird. I heard the word dementia thrown around, and I'm going, well, that doesn't line up very well with performance ability. It's like, there's a couple of things here. Number one, we don't want to get into the appeal to common sense, right? The logical fallacy appeal to common sense. It doesn't make sense to me because none of us are actually medical professionals, right? And there are people who are ill mentally and still work and still perform. Half of Hollywood says they have some type of mental illness and they do.
They're not under conservatorships. But that's the whole issue.
But they are not. But then I'd also say is that going to the fallacy of common sense is that yes, all this stuff looks bad, but we have courts, we have judges, we have medical professionals, and they have been saying this is still on. So now I do agree. It's good to have, hey, I believe this is wrong on its face, but I can also say I just don't have enough information, and then then understand too that without more information to convince me on either side, then how can you can say I think this is poor, I think this is bad for these reasons, but again I think a more refined view would be why? Because we're saying we see this and we're making a conclusion instead of saying, well, what's the other side? Because we're only hearing one side of the story. It seems too long. Okay,
we've heard the other side, and we've heard the other side. We're having two battling fallacies. You got two battling fallacies: the appeal to common sense or the appeal to authority.
Oh no, but
hold on. The appeal to authority fallacy. You're misunderstanding. It's appeal to authority that is not an authority. So, for instance, if I'm appealing to a doctor, a heart doctor about a heart issue, I can appeal to that doctor because he is an authority in that field. So the fallacy of appeal to authority is appealing to an authority which is not an authority.
I don't think that's exactly right. That's not right.
No, look it up. Look it up.
That is not what the
authority. That is not.
If I may, I just want to jump in because there are a couple of points. What Nate said earlier about the fact that we don't have our medical file, I completely agree with, because there is potentially some crucial information in her medical file that we have no access to at this point. We may never have access to it, but there could be. I mean, there are two possibilities that I've recently come across, and one is perhaps early onset dementia. That is possible. You can get it at a very early age, and it is the kind of disease that slowly eats away at your brain. You can still be functioning for a very long time, but you're slowly sort of losing your faculties. Another possibility, and I really only thought about this because of, during her, I came across some of the audio from Britney's statement to the court. She mentioned that she was put on lithium. Now, she may have been put on lithium improperly, for as a treatment for something that she doesn't have. But if she was put on lithium for something that she does have, typically that's used for bipolar disorder, which means that she would have again, I'm not a doctor, but what I do understand about bipolar disorder is that, people vary swings between depression and manic episodes. And men and women, have it differently, apparently. Women tend to be more on the depressive side, men tend to be more on the manic side, apparently. But so that would kind of fit with what happened back in 2008 when she was first put under the conservatorship. And if she does have bipolar disorder, she may be the kind of person that has been under medication and has been managed with that and can manage that herself, as an adult after a period of time of guided management. So maybe in that kind of a situation, it's proper to take away the conservatorship. But if she's the kind of person that really needs to be controlled, there are those people that suffer from the disease to such an extent that they really just need to have that structure placed around them for a very long time, maybe for the rest of their lives. Otherwise, they end up homeless. So, it could be that kind of a situation as well. We just don't know without having her medical file. So I'm not one to agree. I know this is kind of an unpopular opinion with most people, especially with the Free Britney hashtag. But I'm not necessarily ready to say that the conservatorship has gone on for too long and that it should end without knowing that crucial information.
Well, if you're agreeing with Nate, you're expressing an unpopular opinion.
Oh yeah.
But I'll tell you this: I think where Nate and Alita are both coming from, which I would agree with, and as we take Viva on 3-on-1 here, is that this is not a case where there's a politically motivated decision or anything of that sort of kind. We would like to assume that we should be able to trust that there's no reason for a judge to have bias. We've all seen this public evidence which shows that Britney's really okay and she's being abused by being in this conservatorship. And with all of that, the judge has allowed it to go on for 13 years. And perhaps there hasn't been a proper motion to get her out of it or whatever, but there's been enough, there's so much egregious that anyone who doesn't know anything about the case is very easily able to say, let her out of her conservatorship, and yet she's still there, which leads us to believe that there must be other factors. Since we assume the judge is actually impartial and has no reason to be biased, well why would they be biased against Britney specifically?
No, Joe, there's other things that corrupt other than politics, and there's other things that affect a judge's
and money.
Decision. Well, no, not
politics or money.
Just not wanting to be the one to make a hard decision, deferring to the white lab coats, as we've seen time and time again over the last year and a half. And in my limited having done motions for confinement, I can tell you that once a judge is faced with a doctor whose job it is to prepare these reports, to forcibly detain people, that's their job. The report that's going to come out of them is going to say that. Once a judge has that report prepared by a doctor who's in that industry, what is the judge going to do? The judge doesn't want to be the one to defy the doctor, even if their two own eyes are saying something totally different. So they defer to the authority of a doctor who's in that particular business. And in this particular situation, you have people medicating another human being under a curatorship who's an adult, and even if she happens to be manic bipolar, which the lithium is an indication of, even if forced conservatorship for manic bipolars typically are punctual for when the manic bipolar individual is in a state where they pose an immediate risk to themselves or others. To say that they can't manage their money is not what you put someone under a conservatorship for, certainly not one you maintain them under for 13 years. And when Britney says, which threw me off, when she says, I want a conservatorship, I just don't want my father there. To me, it sounds like in her mind, she's equating conservatorship with responsible management, which are two very different things, but which she has quite easily in her own mind confounded, given that she's never known proper management and might think that conservatorship is management. But it's not corruption. It's not like bribes of briefcase under the tables. It's just these judges defer to the doctors, and the doctors are in the business. This is what they do. That's what they're there for.
That's a fair point.
That's a good point. Yeah, it's a fair point.
But when you hear someone talk for 25 minutes, you with that degree of lucidity, where they're in a catch-22 where the angrier they get, the more their detention is justified. The more docile they are, the more the detention is helping them. It's an absolute catch-22. This was never what it was intended to do, and you can't prevent people from living their lives and making their own mistakes, even if you think they're their mistakes. Conservatorship has a specific purpose, and if they're degenerating over the years, that's a different thing. But manic bipolar is periodic as well. So you don't.
But again, I'm not but again, not being a psychologist, not understanding the gradation, because all these mental illnesses, there's a light and there's a one where it's really, really bad. I don't know where Britney is on that spectrum, but just to understand there, just to hammer home this point, 2 judges, multiple doctors, her own doctor, her own lawyer, they had independent lawyers, independent doctors, and all these other things. They're all coming to this conclusion. They all have been coming to the conclusion over 13 years.
It's not her own lawyer. It's not her own lawyer. It's a court appointed.
Yeah,
she couldn't have. That's one of the people have with this. She selects a lawyer, and they say, no, don't like him, and they force her.
Well, just her court-appointed, the attorney court-appointed, just like in criminal cases. Your court-appointed attorney is your attorney. Now, just because you didn't pick the attorney doesn't mean that attorney doesn't have the same obligations, rights, and responsibilities, and even ethical code to represent you, because that is her attorney. So if the argument is because she didn't pick that attorney still has those ethical obligations. But if so I don't think that's enough to say we could just dismiss this independent attorney by the court. Are we really saying that a court-appointed attorney could just be dismissed as somebody who's working for the court? No,
I'll tell you why. The court-appointed attorney himself was saying that perhaps she should be getting someone else. A court-appointed attorney going up against an $800 an hour attorney potentially, and I'm not saying that's what it is, but going up against a super high-power attorney, it's like you're basically putting up a musket versus a bazooka. It's just not. It's just.
How do you know this is not an $800 court-appointed? Like the court-appointed attorney could be somebody from a law firm. They do that too, right? It's based on scale.
If there were no money in here, there would be no detention here. If she were not a cash cow,
I agree.
If she were not a cash cow, and I don't mean that to be derogatory. If she were not the proverbial golden goose under conservatorship, nobody would be fighting this hard to maintain their own livelihoods. These people are now all dependent on this for their own existence, and therefore they are all compromised and should all be removed. Period.
And the fact that she's able to work so much
is going to be compromised, though, because they're going to get paid too.
The fact that she's able to work so efficiently, so much better than all of us combined, and be such a golden goose, it does sort of make you question, like, can she really be that and appear lucid for 25 minutes at a time? It does throw some question on everything. I am curious, Viva, whether you think that the public is more sympathetic to Britney, specifically because we've all been dealing with our own lockdowns. And you could sort of see a parallel here between what the public has been dealing with, where the white coats have all locked us away for considerable periods of time, and them locking away Britney.
I certainly think people have probably gotten a little more skeptical as to the way in which science and white lab coats can be politicized and tainted by irrelevant considerations, but that are very relevant to the individuals making the decisions. But yeah, we've been more sensitized to it, no doubt. And we've been more sensitized to judicial corruption. Doesn't need to be political, but we've seen the way the courts and the judges can render highly motivated decisions for any number of reasons. But I think the public is now very much swayed because they've had their first glimpse into this, because this has been kept from the public's eye for the longest time. And now people heard a 25-minute, I don't think anyone would call that anything but lucid explanation of what's going on. And nobody can understand it. And now it allows people to reassess what they thought they knew from over the last 10 years. And knowledge is power. And people are starting to see what's going on. And people are starting to understand the economics of what's going on.
Those are my big issues, is the people her father being forever conservator and just locking into that position till the end of time. Maybe she does need one. I don't know that. I'm saying that it really should be thoroughly investigated. And I question, why could it not be an independent third party that is, shall we say, not as tied in as, say, her father, which it seems to be causing friction, things like that. Maybe she does need it, maybe she doesn't, but I do question why. I don't know. You can't seem to kick the guy. He's locked in forever. And from the very beginning, she was pretty upset. And I do see Elite, and I'm heading right to her. Go for it.
Sorry, no, I was about to say that I definitely agree that The father seems to be kind of the bit of a shady character, because if you watch the documentaries on Britney Spears' life, he wasn't around throughout her childhood at all until she really made it big. And I think especially right before 2008 when the conservatorship started. So he definitely is a questionable character, and is I mean, his motives seem to be the I guess you could say the dirtiest out of anyone else in this particular case. So I think although I'm not convinced that she necessarily needs to be out of the conservatorship, because I don't have enough evidence really to convince me of that. But I mean, from what it looks like, her father probably shouldn't be involved, at least for a period of time, to see how things sort of stabilize out of that. But unfortunately, now his co-conservator is trying to get out, the Bessemer Trust company. So I don't know what the court is going to do if the Bessemer Trust company tries to get out.
The Bessemer Trust does not want to be involved in an involuntary conservatorship, and so they're making the right decision to dodge bleep out of there. But Alita, I would flip the other way around. At this point, I think we don't need to see evidence as to why she should not be under conservatorship. I think the evidence needs to be compelling as to why she should still be under conservatorship, because that's a massively different way of viewing it. And I think the proper way is, barring compelling evidence, like we saw in her public break in 2008, compelling evidence to maintain a conservatorship after 13 years. It doesn't become the status quo. It should always be the exception.
The reason why I say that, though, the reason why I said that, evidence proving that she shouldn't be in the conservatorship is because once someone is in a conservatorship under the law, that's exactly what it requires. It requires evidence proving that she shouldn't be in it. So, I mean, if we were talking about, back in 2008, whether or not she should be put into a conservatorship, or, at what year after that point that she was then put into a permanent conservatorship, because of course it was temporary at the beginning. If we were talking at that point about whether she should be placed into a permanent conservatorship, then yes, I would agree that the evidence is on that the default is that she shouldn't be in one, and what kind of evidence is there supporting the fact that she should be in one. But now that she is in one, it's legally, that's where the burden shifts.
Yeah, and this I don't know why it seems like, and maybe everyone's just disagreeing with the fact of there are people there are doctors, there are all these people there who have come to this conclusion, and none of us know because of HIPAA laws. Like Viva, you're saying, unless we have the evidence, but though that evidence is protected under laws that say we can't have it, right? We can't publicly have her personal information, her information about her health things. So that's what makes it even more difficult, because right now we're all saying we believe one thing without the information, without this compelling information. And you're saying, well, since we can't get it, we should then go in and say she should be set free of this conservatorship, not knowing what the evidence that's not available to us says, because that evidence can say that she's a danger to herself, and if it does say she's a danger to herself, then we all are like sitting here like, oh my God, well, if we'd have known that, we wouldn't have come to that conclusion. That's what I'm saying. I'm not saying it's wrong that what your conclusion is wrong. I'm just saying I just don't think it's proper to make that conclusion without the actual medical evidence to find out what the hell is actually going on.
I agree with you in part, disagree in part. I don't know what I don't know, but I do know what I do know. And what I do know is that we've heard from someone who has continued to work, build a massive empire, makes a ton of people a lot of money who are there, basically her confiners. We know what she is doing. And so now we know what she is doing. We know that she is functioning. We know how she is functioning. And we now know her stated desires in a 25-minute discourse to the court. That's what we know. So to go from there and say, well, I don't know what I don't know in terms of what justified it in the beginning, or what could have possibly justified it in the interim. We're dealing with someone who is fully functional, who might have some issues, but is by all accounts fully functional. And then to throw my own baggage in there, I'm looking at her social media account and her Instagram account, and if the conservatorship is in fact handling that like I think they are, it even adds more concern to me that the conservatorship is just bilking her, quite literally like the golden goose. And it turns my stomach. From what I see and from what I know, yes, I don't know what I don't know, but I do know what I do know, and based on what I do know, this smells fishy and looks bad all around.
Yeah, I'll agree with you. It does. That's a good point, Viva.
And over the last 20 years in general, society has made this massive push towards assessing everybody as having some sort of mental imbalance, which needs rectification through medication or more serious intervention. And I don't think that's really help society. If anything, I think that a little in general, there's this rush to assume that, oh, okay, she had a mental breakdown and she looked crazy for a period of like 2 months. And that means that she has to be on lithium for the rest of her life or some other medication for the rest of her life. And I wholly agree with Viva on that this sort of situation needs to be reassessed. And because, she went through a rough patch there, and she she certainly seemed like she needed help back then, but to just let it go on and on.
But Joe, there's a lot of assumptions that we're making here, right? We're making assumptions that every year they don't reevaluate her, right? We're assuming that 13 years ago what happened is the same reason why she's under the conservatorship today, right? Things could have changed, right? There could be other reasons, right? She could have had different types. So just to say because this happened 13 years ago doesn't mean she should be under conservatorship 13 years later. It's a good statement, but we don't know if that's even true, or even if any evidence is if that evidence is what's keeping her under conservatorship now. It could be a totally different situation, or it could be a deteriorating situation. That's all I'm saying. And I agree with you guys. I honestly agree with you guys. She should be under what we have now. There's a lot of smoke, a lot of fire, and there's a lot of questions that should be answered. But to just jump from that to say, well, she should be out of the conservatorship because we who are not doctors evaluate it as being a bad thing. I just can't go. I just can't go that far with you guys. You know what I mean?
I don't think anybody said that technically. And on that note, the part I wanted to bring up, Nate, you said, "Oh, HIPAA and this and that," so we know all this. That's the scariest part of this entire case. I know Elite is there too. The scariest part of the whole thing to me is that you could. I'm not saying it's true, but you have the perfect ingredients to have somebody in an absolute hell where they have no way to get any word out, no way to escape anything, because every bit of policy and law and everything else is working to keep this in absolute darkness. And I think my biggest thing is I want to know, without breaking anything real, that she actually is getting her voice and actually is being taken care of. I don't know her final state. I am not saying she should not be under conservatorship. I'm saying it really needs to be very seriously explored. And I'll go to Elite. I'm sorry.
Yeah, there's definitely, there definitely are plenty of questions that have been raised, especially in the last week. We haven't even mentioned the allegation that she's had a forced IUD so that she can't have children. That is pretty outrageous, I think, under any conservatorship situation. So there definitely is a situation here that probably really needs to be reevaluated. However, another point that I really think about here is the fact that the whole point of a conservatorship is to protect the conservatee. You're protecting them from being abused by other people. And in this particular case with Britney, before she was put into the conservatorship, if you watch the documentaries on her situation, she was already being kind of targeted by people that were sort of waltzing into her life and claiming to be these personal gurus and taking all kinds of paychecks from her even before this conservatorship began. So my biggest concern would be, if we were to just throw open the lid and take her out of the conservatorship and let her run free, now all of a sudden you have people that are going to start swarming in and start taking advantage of her in ways that they were before the conservatorship. But at least in this situation, we're under court supervision. I know that it hasn't been ideal, and there probably have been abuses of her under this conservatorship, which is not right, but elder abuse is something that happens all the time. She's not elderly, but typically conservatorship cases are for the elderly. And elder abuse is one of those things that is a serious problem in the United States that doesn't get talked about nearly enough. And that usually falls under these kinds of conservatorship cases or, situations that should be under conservatorships.
It could be that her medication makes her someone who's not a healthy candidate to have children. That could be the reason for the IUD. If she's taking something like lithium or something like that, it could be that would lead to birth defects or something like that. I don't know.
I've been on mute. No, but actually, sorry, I got it. Verum Crepitus just said, can she choose to make her medical history public? She can't choose to do anything right now. She cannot make any decisions under the conservatorship.
Right, I didn't think about that. So even if she wants to
do anything,
an adult in a way. Maybe I'm making a wrong analogy, but I think of a conservatorship as saying that she is a minor or being treated the same.
They have infused contractual elements into regarding her conservatorship into contracts. This whole thing, Theophastrus, I appreciate there are, I appreciate there are things that, we never will know everything. I will err on the side of giving people their freedoms and letting them make their mistakes, even if they happen to have a diagnosed mental illness. This is not a situation now where anyone who has a diagnosable mental illness, even in law, can get placed under a conservatorship because someone else can make better decisions for them than themselves. I mean, people are free, and even when you have a mental illness, it has to be under the most dire circumstances to create a conservatorship or forced confinement. And then typically that has to be very limited, and then the person has to be let go. But this is like, once you're in this system, she's literally in a system that she cannot get out of because she can't even make any decisions on her own to get out of it in the first place.
Yeah, I do want to agree with Alita though. One of my first case, actually, I was still in law school and I was practicing. I was able to practice in law school. So in law school, my last year, my first case was a elder law case and a conservatorship, and everything Viva's saying is true. It was, she couldn't release her medical records because she was under the conservatorship. She didn't want to be in the conservatorship. She sounded all good to us, and we had to fight tooth and nail to get this elderly woman out of the conservatorship. And it seemed like the conservator was stealing her money. It was like a horror show, right? Doctors and all this other stuff. And at the end of the day, we were successful at getting the conservatorship removed. And then even the judge got mad at us. Like, why are you even guys getting involved? This is an old woman. She's living by herself, but she wanted to end the conservatorship. So I do understand. The courts get it wrong. We don't live in a perfect system. I know a lot of people like, why are you trusting the state? Why are you trusting the government? Because this is the best damn government on the planet Earth. I love the United States government. I'm a patriot. I'm sorry. And I think the court system gets it right most of the time. And I do think it's not a perfect system.
You love the government, Nate.
That's true. I do. I love my country. But I'm going to say we get it wrong a lot. And I'm not saying that it's not that in this case, it's not wrong, right? I'm not saying that Britney's got it wrong. I'm just saying it's just, I just want to hear from the other side also. And maybe that will never happen, but what I hear now is obviously a problem, but I do want to hear from the other side because there's a reason, unless we're saying both these judges are corrupt, all these lawyers are corrupt, all the doctors who've been saying, everybody's corrupt and everybody's got a price. And that's why Britney's, that makes less sense to me. Then I just haven't heard from the other side because there's got to be some rational reason why these judges with an S have come to the conclusion that this needs to continue. I don't know what that reason is. I only heard one side of the story. Now I would like to hear the other.
A U.S. gymnastics team, and how could that technically be happening to all those athletes? How is that possible? There's so many people around. How could it happen? Nobody you'd see. It can't.
For the judges or for the?
Well, I'm just saying that just because there's a lot of people involved, one, everybody's deferring to everybody else's expertise. You could technically have one bad actor who swings a whole lot of vote or can manipulate a situation.
Or scarier yet, there are no bad actors. There are just doctors who are in the industry of diagnosing who think they're doing the right thing. You have a judge who's in the industry of listening to experts and he thinks he's doing the right thing. He's applying the law as it exists. He thinks he's doing the right thing. The road to hell is paved in good intentions. And that's where I think we're at. It's not some evil, whatever the rubbing hands thing. I bet you everyone thinks they're doing the right thing. They're just viewing Britney as a patient and not as an individual who is free to make mistakes and is free to live freely, even if it means living freely with mental illness. The mental illness confinement has to be punctual. It has to have specific issues like immediate risk to self or others, and not just the inability to manage your $60 million when you're working 7 days a week with a Vegas show. I mean, that's not what it was for. In my humble,
how do we know that doesn't apply to Britney? How do we again, we don't know if any of this applies to Britney, right? We don't know.
We don't know what we don't know. We know that she's
exactly
an empire. She's working. She's functional. She's performing. She's business savvy. She's social media savvy. We know what we know. I will never know what I don't know.
There are people with illnesses who do all that stuff, right? There are people
there's people with illnesses who do all that stuff. They're not people with illnesses who do all that stuff that are under conservatorships under these circumstances. So I would have to not know something shocking. Like shocking in order to
like she were all her doctors say that she's a harm to other people. Like all her doctors say that she's a threat to, that there's a threat. Like there could be something out there that can change your mind. And if you're just saying that all the facts now and they lead you to the conclusion without hearing the other side, then I just
if she's a risk to others. If she's a risk to others, we would know that.
How would we? How would we?
Yeah, she's locked away. How would we? Or a risk to herself.
How would we know? It's not like her medical things are open.
No, but if she's a risk to others, but has actually not done anything that would have materialized that risk. All right, well, we'll never know what we can never prove. But I just had I lost my thought. Britney. Oh, for goodness sake, I lost it. It'll come back in a second.
No, you're right.
Happens to me too often.
I do want to say this. I do agree with you in principle, Viva. You are 100% correct. I can't even argue with a lot of your points. I'm just saying there's another side to the story I think we're missing. Everything you're saying is true. I agree with that.
If it were to come out that she were not telling the truth about the forced IUD or the inability to remove the IUD, if that were not true, then I can understand that someone is having certain thoughts which are fabricated. But even then, man, like, this is not what it was ever supposed to be about. And it's in a system where you can never get out of it once you got in there in the first place. And the ultimate irony is that this is a deterrent for anybody who actually needs to get help, because nobody wants to find themselves in this situation. And when they see this, they're going to be very reluctant to go to a system that's going to suck them in and never let them out.
Isn't this a voluntary conservatorship too?
It is a stated voluntary, but it's not clear voluntary for whom and under what terms.
The point I think, Viva, that Nate is making is, for all we know, she got up there and sounded so completely lucid, and she's like, I can't even get my IUD out. And for all we know, she only believes she has an IUD and doesn't even have one. Yeah, that's what he's saying. Like, we don't know if she could be literally like insane and that we wouldn't know. So
completely agree. I mean, she could be saying all of these things. I mean, one of the other things that she also said was that she didn't know that she could try to get out of the conservatorship, and her attorney, maybe he's lying, but he has professional responsibilities to tell her what her options are. And he says that he's been giving her those over the years. So either she's lying or he's lying. And, as we all know, lawyers are terrified of, professional responsibility claims. So my personal bet would be that he's probably the type of attorney that has been actually concerned with his professional responsibility requirements and has actually been telling her what her options actually are, including getting out of the conservatorship. I mean, that is, granted, that's kind of an assumption that I'm making, but I probably could ask around back in California, other attorneys that know this attorney to see, what his reputation is. But I don't know. But anyway, but this is that's just my.
And I do think there's one point that needs to be made too. A lot of the issues that Britney was complaining about were really about her personal conservator, right? The woman who's a personal conservator who now needs more money because of death threats. It wasn't actually her father, right? Those weren't her father issues about working and all that stuff. It was the personal conservator. So everybody's like dogpiling on the father about his role in this, when it was actually another conservator who was telling her, this is what you have to do to work. This is what you got to do. So that's what I'm talking about. Even just this little piece of saying, we're actually blaming the wrong person because it's another person who's making these decisions, I think should give people pause and say, okay, we need to actually understand the full story from both sides before we can come to some conclusion.
All right. Well,
can we get to
a conclusion on this one?
I just wanted to, just before we wrap up, can we just walk through what Nate believes the logical fallacy of appeal to authority is? Because what you were saying before is not something I've ever heard.
I used to be in this philosophical community. So I used to always say it's appeal to authority is whenever you say somebody said something or whatever, right? So then then somebody actually, I looked it up in both Stanford and some more. So it's an informal fallacy. Now, generally, appeal to authority is appealing to an authority that's not an authority or that doesn't.
But even if it is an authority, it's still a logical fallacy.
But if now. It all depends. I can appeal to an authority that is an authority. So if I have an authority, and we do it all the time, and it's not a fallacy. So it's about number one, identifying that this is an authority, and then you can say, well, this authority says this. Now, whether that statement is true or not, that's you can definitely that's the issue. It's just that because the authority says it's not true. But the fallacy, the technical fallacy, is appeal to authority that is not an authority. It's actually an appeal to a fake authority. But I totally do understand the difference.
No, I'll give you proof. I'll give you an example. Okay,
go ahead.
We should all wear masks because Dr. Fauci said so. Now he's a genuine authority, but that's a logical fallacy.
Well, I'm going to trust
appeal to authority. What I'm saying is it's a logical fallacy of appeal to authority. You're relying on this medical expert to say that's the proof that we all need to wear masks. That is a logical fallacy of appeal to authority, even though he's a genuine authority.
Look, I think bottom line.
All right, I wouldn't call that an appeal to authority fallacy. I don't think that's a logical fallacy. Like an appeal to. Go ahead.
Not that the internet is not that the internet is the best place on earth. I have not seen one definition that defines it the way you do. There's one definition that says appeal to authority, whether the person is an authority or not. But I think by common parlance, as we say in France, appeal to authority is someone who I deem to be an authority says it, therefore it's uncontestable.
That's because we do it as lawyers. We definitely appeal to authority. Supreme Court says X, right? The law says X. This is an appeal. So every court case now, when we quote the Supreme Court, you can say it's an appeal to authority, which is a logical fallacy. Which again, hold on. Which is not the case, because you can appeal to an authority as long as they are an authority. And I think there was maybe a second piece to it. But again, I could be wrong though. But if you think it is,
and the difference here, Nate, the difference is if the court makes a legal finding and says this is the law, this is our finding here, then that becomes a fact under the law. Does it actually make it true or false? No, as we said in the very beginning of this conversation, there's a difference between what is true, what is not true, and what is proven and what you can prove in court. But under the law, it's considered true that this person is a murderer. So whether they actually murdered or not, under the law, it's true that they're a murderer, even if they never killed anyone in their lives. Now, as opposed to when a legal expert walks into court and testifies, and before it's adjudicated, for you to say it must be true, this medical expert says it's true, ergo it must be true, is not something that the law recognizes, and it is a logical fallacy to say that it's proven
judicial
true.
notice. If all the experts say blah blah blah, and it's an obvious fact.
No, that's not judicial notice.
You can get judicial notice if you have an expert. If you have two experts come, right, both sides agree these are the experts, and the experts say this is the way it happens. It can only happen this way. And then you could actually ask for judicial notice for that opinion, right? So that is a fact, right? It happens all the time.
Yeah, but that's the judge will decide this warrants judicial notice. The same way, in other words,
it won't be an appeal to an authority. He's using the authorities to get them to make the determination.
Let me block it.
We're gonna wrap on this.
I can clarify here.
Twitter.
The appeal to authority. Am I on mute? No. The appeal to authority is a fallacy when one legitimizes their position by relying on the authority without the argument. Invoking an authority is how one proves one position. So,
good. All right, that makes sense.
Yes, with that said, everybody, please consider checking us out on unstructured.locals.com. That's me. vivabarneslaw.locals.com. That's David. NateTheLawyer.locals.com. That is Nate. And GoodLawgic.locals.com. LegalBytes. Not yet, but check out our channel, guys. Let's help grow our channel, see if we can bring her back. And you're also at LegalBytes Media on Twitter.
Yep, and that's correct.
Everybody who wants to, please pile on Nate, and we'll keep the going on Twitter or in locals at Nate the Lawyer. He wants to hear from you.
Yes.
And make sure to attach every article that you can.
Nate,
I agree. I agree. Joe may be right, but I'm just not convinced. But go ahead.
Joe is right.
Expect a meme on the internet, Nate. It's going to be Nate's face with two thumbs up, and it's going to say, "I love the government" above you.
Oh yeah.
Hey, I do. I'm a patriot, baby. I love my country. What can I say?